Good morning, Jenna Liberty Lion. I'm going to continue to cover the information on agencies and how they're contracting with people to um, get them to be obedient to the agency's policies, that these policies are not the law, but once you sign the contract, it becomes a law. And if you've been watching my channel, you've heard me say repeatedly that the law is in the contract and then the contract is the law. So the law is put in the contract, you sign the contract, and once you sign it, it becomes law. Legal tender is a contract. It's when you use it, it's, to my understanding, an implied contract. So I have a list of things here that I've written down that is maybe more organized to help people understand the facts, to be able to see the evidence, and then we'll talk about how things are written in such a way to make them appear to say something that they do not appear, that they are not actually. And we get these ideas of things not being what we think they are from Language, Truth, and Logic, from Alfred Jules Ayers, Stephen Schiffer Meaning. And then we get the idea of blending and the various ways in which things are categorized, and it all results in fictions. So we have this book on blending, and then we have this book which talks about categorizing and how courts categorize things to make it look like you're part of something that you're not actually part of. So my theory, and it's not really a theory because I have evidence to back it up, is that the Constitution, the federal Constitution, was intended to be a military constitution. So in the Congress, in the congressional records, the journals of the American Congress from 1774 to 1788, in volume 4, they said, quote, to take into consideration for the purpose of forming a military peace establishment. And in the 1700s, I don't have the exact date here, it's in my book, Hamilton called it a military constitution. So before the Constitution was written, after the Articles of Confederation were written, they knew that they were going to need a military constitution. Now, there's a lot of different talk about the Articles of Confederation were inadequate, they didn't get the job done, and all these sorts of things. But in my opinion, based on what I've read, that was never true. That when they wrote the Declaration of Independence and they wrote the Articles of Confederation, they knew that at some point in time they were going to need a military constitution. So in the Articles of Confederation, you have delegates who assembled and called themselves the United States of America, and Congress assembled. But in the Articles of Declaration, or in the Articles of Confederation, they also created something called the United States. And when it assembled, it was the United States and Congress assembled. And the United States had military powers. So in the journals of 1774 to 1788, it called it a military peace establishment. Now, Hamilton was writing to his friend who lived in France, and before the Constitution was written, he asked him, hey, can you come help us write our military constitution? So the preamble of the Constitution is also evidence of it being a peace establishment, a military peace establishment. So it says the United States, which is the military, we are establishing a peaceful state. for the United States of America. Now, often people don't write letters to themselves. So if they were both the same thing, it would be really weird to have a preamble that said, I'm writing this letter to establish peace to myself. Because if I needed to establish peace to myself, I wouldn't need to write a letter to do it to myself. I would just do it. But because it's a federal military constitution establishing peace, they're promising the United States of America that when they take an oath to uphold and defend it, they're taking an oath to uphold and defend peace as a military for the thing that created it, the United States of America, which are the states. So Hamilton wrote his friend before the Constitution was written and said, hey, can you come help us write our military constitution? At that time, France was one of the most free societies there were. So in the preamble, it says justice, defense, spelled specifically with a C, which is different than being spelled with an S, and tranquility, general welfare, blessings of liberty. These are all words to establish peace, and it goes along with the journals of the American Congress forming a military peace establishment, and Hamilton's letter where he wrote his friend asking for help in writing the military constitution. The Constitution of the United States is a military constitution that works for the benefit of the state. So the word for has a lot of different meanings depending on context, and a lot of words have different meanings depending on the context you use them. But when you say, I do this for this person, you're establishing a situation where there's a truster and a beneficiary. So the United States is like the trustor, and the United States of America, or the states, are the beneficiary. And that's the way they use the word for in wills and trusts. So we, the people of the United States, meaning the military, ordain and establish this Constitution for the United States of America, which are the states. So in other words, the military works for the states. The president, further, this is more evidence, the president has two offices. He has an office as the executive of the United States of America, and he has an office of commander-in-chief of the military forces. The Articles of Confederation within it establish the military. It says they sent people from the states. They sent representatives, which they called themselves delegates. And they said delegates of the United States of America in Congress assembled. And then they wrote the rest of the Articles of Confederation, but in Article 2, they created the United States in Congress assembled, which is a military Congress, or a federal Congress, which has certain powers during wartime, and it has certain powers to keep the peace. And when they get together to do things, they are drawn from the members of the military, and each of those military members are citizens of the United States, or a citizen of the United States. All three founding documents, the Declaration of Independence, Articles of Confederation, and Constitution of the United States for the United States of America, end with a statement of independence of the United States of America, not the United States. Since the military is not independent, it was created by the states and it has no sovereign power. It always has to abide by what the states tell it to do. My opinion is that the states now are using the federal constitution to pretend like it has the power that a military would have. The military has special powers. The states have sort of a general power. So the independence belongs to all the states. And Article 2 of the Articles of Confederation also states that, where it says, each state shall remain free, sovereign, and independent, with all rights, powers, and jurisdictions not given to the military, to help establish peace and fight wars. And I think the reason for that, having it done this way, is because when the Revolutionary War started occurring, they couldn't get people to help fight. They couldn't get Congress of the United States of America to show up. So they needed a document that would help them make sure that in the event of a war, they could order people to show up. Because civilians, the civil people under a civil government, cannot order other people to do anything. But if you join the military, you're subject to that jurisdiction, and that jurisdiction allows for you to be ordered. And if you don't show up, they can send people to go get you and bring you in. And that was because they joined the military, and because during the Revolutionary War they couldn't establish a proper Congress. So they needed to make sure that they could always establish a proper Congress to help fight during war. And they did that by creating a military Congress where the members, the representatives, and the senators could be ordered to appear. Let's see. And if they didn't come by order, then they were probably dead, or someone would go and get them, or someone would sit in their place, which I think is a presidential function. The president can put somebody in that place, but he has to draw from the either non-commissioned officers or the troops for representatives, or the commissioned officers for the senators. So all three founding documents, Declaration of Independence, Articles of Confederation, and the Constitution of the United States for the United States of America, end with a statement of independence of the United States of America, not the independence of the United States. That's because the military was created by the states. The military has no sovereignty. They have to abide by what the civil class of people tell them. The civil government is always higher than the military government. So, and that's in the Texas Republic Constitution. The civil will always be higher than the military. So what you have right now are all these agencies created by the United States, which is the military, that are going out and contracting with people and pretending like it's the law when it's not really the law, and they don't even have the authority to do things off federal lands unless the governor calls them. But basically the states were taken over during the Civil War, and people friendly to the military, growing itself into a government, were put in office, and it's been that way ever since. However, there's a commercial side of all of this, which we'll get to. So in Texas, the Texas Jurisprudence Manual, the 3rd edition, which is the most recent edition, defines a state as a political society. The United States is a military political society. So the United States is a military state. It means that the federal lands inside Texas make up the federal military state. Those who are not in the military service of the United States are subject to the jurisdiction thereof. So we're going to the 14th Amendment now. Who are under federal and state jurisdiction, within or with federal jurisdiction being the higher of the two, since the person is in the military, but civilians are not subject to federal laws, that is, laws of the United States military peace establishment. Okay, so this might sound confusing. So when the Republic of Texas, or any of the republics, is supposed to work this way. For some states, I've learned it hasn't exactly worked this way, but this is generally how it was meant to work, so that it would be completely legal, where the contracts are perfect, right? So that it can't be argued later. So legal is contract. So all these contracts, Declaration of Independence, Articles of Confederation, Constitution of the United States, are all contracts, and they needed to be perfect and legal and legally sound, so that later it couldn't be repealed very easily. So the military, well, the republics, each state had to form a republican form of government, a civil government that represented the civil class of people. Civil means you're not in the military, or you're not a subject to someone. So you're a civil person. You form a government called a republic. So there were several republic constitutions created for Texas and the people, the civil people in Texas. Some of them didn't work right. So they kept going and showing the federal government, here's our new constitution. And they would put it into play and they'd kind of see if it worked, I think. And then if it didn't work, they'd create a new one. And that's why Texas has like 2 or 3 of them. Some other states have other ones of them. So once they came up with a republic constitution that did not conflict with the federal constitution, that constitution was ratified, put in place, and then stayed in place. So people think that the republics were repealed or replaced, and then we got the state of whatever, but that's not true. So my research shows that when the Republic of Texas was formed and the federal government said, yeah, that's good, it doesn't conflict with our federal constitution, then that Republic Congress could then designate lands to be given to the United States. Certain lands, not the whole land, not the whole state. Certain lands within the boundaries of Texas, which could be used for military posts. Those military posts became federal lands. So in order to not conflict between federal and state, the State of Texas Constitution was created, which is the constitution that the federal people are supposed to follow as far as state jurisdiction, not to impede on the civil class of people. And what the state wanted the federal government to do or not do on the federal lands, as long as those things did not conflict with military works. That's the whole big thing here. It can't conflict with what the military is doing. It can't conflict with military works. But the military can't just arbitrarily come off federal lands and start doing military works among the civil class of people, intruding on their government, our republics. So there was a State of Texas Constitution created that said the military will not, that the military, if they come off the federal lands and they break some of our laws, that they are subject to the jurisdiction of the republic, of the people. So as expected and as has happened, the founders knew that the military would grow itself and become something bigger than it was, and so they set boundaries down. They gave the state power over the militaries in their state as long as the states didn't interfere with whatever the military was doing on federal lands. Okay, so you have these 2 jurisdictions. You have a state, a military state inside Texas, and then you have a republic inside Texas, and they needed to make sure that they didn't conflict. And so that's why they came up with the State of Texas Constitution. Now later, during very, very well around the Civil War, they changed this military into a commercial state. So it went from a military state to a commercial state, thanks to people, or no thanks to people like Rockefeller and Lincoln and some of the others. Okay, so the 14th Amendment, when it says subject to the jurisdiction thereof, they're talking about the military people on federal lands inside a state, like let's say Texas, that they're subject to the laws of the Republic of Texas, but they're also subject to federal laws. So they're subject to the jurisdiction thereof. So some of these people might not be in Texas. They might be in a state somewhere else, like Virginia. So to avoid having a standing army, what they did was they started moving their military around. And then they claimed, I think subjectively, that created a situation where the army wasn't standing because they weren't always in the same place. They were being moved around. And so the 14th Amendment comes back and says, well, they're subject to whatever jurisdiction of whatever state they're in, but also to the federal jurisdiction. So military people, while on federal lands, and really 24/7, they are subject to military law. They're subject to rules and regulations and the laws of the Constitution. But when they go off federal lands inside, let's say Texas or Virginia or Oklahoma, wherever, they are still subject to our civil laws, our republic laws. They can't get out of that. If they weren't, so we have to look at the opposite. Like what's the contradictory thing that could happen? If they weren't subject to state laws while they were in the state, they could rain terror upon all of the civil class of people. They could steal, murder, whatever, and then run back to the federal lands, and there's no consequences. And the state can't go and get them because they're on federal lands. So there had to be an agreement between whatever state and the federal government on what's going to happen when these military people come off federal lands and they go into the state and they commit crimes. So some states reserved the right to go onto the federal lands to capture people. Some states just said, we're gonna ask you for the person and you're gonna give them back. And there's all these different nuances to the jurisdiction, that to both the jurisdictions, both the political states being able to work things out ahead of time, so that each political state knows where they stand with each other, and all the people know where they stand with each other. If there weren't a state of Texas Constitution, when there's a conflict between the state and the federal government, they might not know, who has the power over the person, or who has the right to make the laws. So in Texas Jurisprudence 3rd edition, under statehood, states that the laws of the Republic of Texas are abrogated, my word, only their words, insofar as they conflict with federal authority, or that is to say, the Republic of Texas cannot interfere with military works. So on my orange paper, I printed it out. It is Texas Jurisprudence 3rd edition, I, in general, subsection 1, statehood generally. So the United States Congress and the Convention of the Republic of Texas, so they got together to form the State of Texas Constitution. The state of Texas became a state on equal footing in all respects with the original states. Okay, that's when they joined in the Articles of Confederation, they joined the Confederation. So the Republic of Texas joined the Confederation. Now, why would you join the Confederation knowing that you're going to make a military constitution at some point in time as a member of this institution, the Confederation, and then turn around and destroy your own republic and create a new state? It doesn't make sense, because they knew they were going to do it all along, right? They knew that they were going to create a military with a federal military constitution all along. So why create a republic just to turn around and replace it with the state of Texas Constitution? It doesn't make any sense. So what the reality is that the Republic created a Congress, a Republican form of Congress. They joined the Union under the Articles of Confederation. They made sure that their Constitution did not conflict with the federal military constitution once it was created. And then they worked out the jurisdiction between the Republic of Texas, the civilians, and the military. And that's in the Republic of Texas Constitution. The civil is always higher than the military. They had to work out their military state and their civil state and all the nuances so that they didn't conflict. And it says in here that it became a state on equal footing, and that the Republic Constitution was abrogated insofar as it conflicted with federal authority, and the Constitution and the laws of the United States were enforced in Texas immediately on its admission as a state. So then we got the State of Texas Constitution, which is the working out of the jurisdiction between the federal government or military state inside Texas and Texas. So anytime you put a state within a state, you have to have worked out, at least to some general extent, who has what power and who's over who and who's subservient to who. So we have a republic constitution that says for some reason it's the most powerful, and a military constitution that is inside Texas, which has another constitution that says we have power for these purposes, and they work together very well. There's not much conflict between the Republic of Texas and the federal military inside Texas under the State of Texas Constitution, other than the fact that all these agencies has grown themselves. The Constitution for the military has been turned into a commercial contract regulating commerce, and then the military created all these, or the United States military has created all these agencies that then it tries to contract with people continually to bring in money, to generate revenue. So they tell you that all these things, all these laws are laws, but they're not really laws. They're policies created by agencies, codified, and then they get you to they advertise by way of their applications and their salespeople, which are sometimes their cops, or the lady that comes to the hospital and says, you got to get a birth certificate for your kid, so they can participate in the legal state or the state contract state. But that wasn't what the United States was actually erected to do. It was erected to protect us, not to contract away all our rights. It was there to protect our rights, not to contract our rights away. It says, the Republic of Texas Constitution states that the civil authority is higher than the military authority. That is to say, the military is subservient to the states. However, the states have agreed not to interfere with military works. So you have a military post inside Texas. The military post has a fence around it. The top of the fence has barbed wire, and that barbed wire leans out. That is to make sure that nobody gets in, so that people can't get in. It's not to keep people out, because they can come out, but we're not supposed to go in because we're not supposed to interfere with military works. For all other purposes, the Republic is higher than the military, or the civil class is higher than the military. Republic form of governments were required to be in place prior to joining the Union. Once joined, the state of Texas, a military federal state, wrote a state constitution for the jurisdiction agreement between the Republic of Texas and the federal military in Texas. The federal military in Texas is the military state or political society. The state of Texas Constitution was to settle particular jurisdiction issues between the military and civil people and their republic form of government, the Republic of Texas. It was all about creating the military. It was all about protecting the states and all about protecting the people. The Federal Military Constitution of Peace is the law of the land. Any Supreme Court case or opinion cannot be interpreted beyond the basic premise of the military constitution. That premise is one of peace. Even if the military must be used to bring society back into order, the law of the land guarantees to each state in this union a republican form of government. In other words, the civil state is protected and guaranteed by the military, acting on authority of the Federal Military Constitution of Peace. Safety and security is the supreme law of the land. Safety and security of the people is the supreme law of the land. That doesn't mean interfering with them and contracting with them and taking their rights away, which creates a not peaceful state, because now people are upset that their rights have been taken. West Dictionary defines transportation as one acting in the capacity of a carrier, meaning he or she is working transporting people. So this is one of the ways in which they take things out of context. So every title and every code has to stay within context. So no matter what word you use or what phrase you use, it has to stay within the context of that particular code or title of code. So you can't say in the transportation code, all drivers, and then go out and tell someone who's not acting in a commercial activity as a carrier that he's one of the all drivers. It has to stay within the context of the code. So transportation, for example, this is just an example of how they switcheroo and they recategorize and they blend things together that don't really go together. They say that anyone driving is subject to all the transportation laws, but transportation is specific to carriers. Carriers is specific to people getting paid to move things. So if they're trying to force us into these contracts, they're already breaking the Constitution, because the Constitution and the I think the Bill of Rights or one of the amendments says that no man is subject to involuntary servitude. So they can't force you to sign a contract. Contracts must be legal and must be voluntary. They're a form of legal tender. The Constitution requires the federal government to obtain consent from those seeking to enlist or become an officer through an application process. And they advertise. You see their advertisements on TV. All the agencies that are part of the military industrial complex, which is all agencies of the United States, are allowed to contract and allowed to advertise those contracts, allowed to send out applications and have people apply for things like a driver's license or a birth certificate or whatever to pay taxes. It's all advertisements. And they're allowed to advertise. It's in their laws that they're allowed to advertise contracts. They contract for good purposes, like having people come on military posts and build houses or buildings or whatever, but they also do other types of contracts, which is to come off the military post and create a police state among us of our own doing, because we've volunteered for their driver's license, which is a commercial contract, which controls your vehicle, your movement, the registration of your car, your license plate, all those things. So these contracts are a form of legal tender because they have to remain current, and being current, it has a currency, and legal tender is a currency. The Constitution requires the federal government to obtain consent from those seeking to enlist or become an officer through the application process. So these are the contracts that the founders intended, or some of the ways in which the contracts the founders intended, but they've, like I said, they've created these agencies that come off federal lands, and then they contract with us for all kinds of purposes. There's no force that can be used by the federal government because of the involuntary servitude. Even your enlistment paper, when you sign your 18, I forget what it's called, your 18-year-old males have to do this document and sign it. That's just an advertisement. It's a contract. So then they can draft you because you voluntarily agreed to be drafted by signing this paper when you're 18 for males. There's no force that can be used by the federal government. The federal government cannot give to its agencies a power that it does not itself possess. The state of Texas, being the federal military political society inside the boundaries of Texas, and the agencies of the state of Texas must also acquire voluntary consent to obtain the power of authority over a person by way of driver's license, registration, tags, marriage, birth certificate, etc. It's the state of Texas, and state of Texas agencies had power. If Texas agencies had power over people without the people performing an act of agreement or contract, the agencies would not need applications. So if they had the power to force you to follow these laws, they wouldn't need you to apply to follow them. They wouldn't need your signature, they wouldn't take a payment, etc. So it's all about contracts and money. Agencies make policy, codify the policies, and pass them as if they were legislation, and advertise it as law and send it to their salesmen, like police officers, teachers, judges, whoever the lady is that comes to your room in the hospital when you've had a baby, their CPS people. All these people work for the state of Texas. So they changed our military contract into a commercial contract and started contracting with us for taking all of our rights, basically to bring us into their system as a way to generate revenue for them. So agencies have no authority over you. If they did have authority, they wouldn't need you to volunteer and sign their contracts. They wouldn't need so many police out there running around catching us like pirates on the sea. No voluntary contract may be contrary to right reason. So this is a philosophical saying that was found in Hamilton's library in one of his books on nature and the law of nations. He says, Aristippus says in Diogenes, quote, that all mistakes deserve pardon because no person is mistaken willingly, but as he is compelled by some perturbance of mind. Like the cops, they come out and they do all these things, and they have this pretended authority. They're wearing all these, guns and badges and stuff all over them, and they say things as if they're ordering you. Well, they're ordering you because you agreed and you signed the contract and you have a license and you registered your vehicle and all that contractual stuff. And so they come at you and they say, well, you have to do this. They're really just salespeople selling the policies that are written in the contract. They have scripts just like salespeople do. Furthermore, the quote is over, but in the book it continues, furthermore, men are not inherently bad unless they have something inherently wrong with them. So what is the purpose of all these contracts? Really to get us to be obedient, when naturally people are kind of obedient anyway. That those people who are not obedient have something wrong with them. And in society, if there's something wrong with somebody, you can usually spot them. You don't need to contract with everybody to find one person that has something wrong with them. So it's all about generating revenue, about creating a artificial power, or the idea of having power in order to create revenue for themselves to send off back to the military, and then to enlarge itself and continue enlarging itself. So this is the military that has broken off from its original intent and become something bigger. That's what it appears to be like. But I think in reality, it's not the military at all. I think the military are just complicit because they think, well, we take orders from the civilians. And if we take orders from the civilians and the civilians tell us to go out and do all these bad things, then we follow orders. And they think that that's what the Constitution says, but that's not what the Constitution is saying. Because the Constitution does not give anyone the power to create a police state or a standing army. So if the land and naval forces rotate people around from state to state to avoid having a standing army, why then is it that the police created by the federal government, called officers of the state of Texas or whatever, are really military people, really under the federal military constitution? Why are they a standing army? Why is it okay for them to be a standing army? Well, it's not, but it appears to be okay because that's what's just become normal, for one. And two, the military constitution has been misperceived and taught to us to be a commercial constitution where the federal government regulates commerce. So there's no medical condition that I know of or have been diagnosed with, and none that exists, that makes a person who wishes to be private inherently bad or immoral. A person who does not wish to voluntarily contract with various agencies to have his rights removed, I would argue they have something wrong with them. So if you're someone who wants to contract all your rights away for this pretend safety that really just enlarges the military, which is not really the military, but the corporations who've overtaken the federal constitution and made it into a perceived document of commerce control, they have something, those people that think that's okay, they have something medically and mentally wrong with them. Many people look for a way out of agency contracts, not understanding that no agency will write policies allowing people to stop paying them money. People have those rights automatically by being human, and those rights do not come from and are not protected by the agencies that rely on people signing contracts to become a financial support system for the various agencies. Our rights come from God or nature, or wherever you think they come from, but not from agencies needing money, just like they don't come from a car dealership who wishes to make money from contracts for car loans. Okay, so they're just acting as any commercial activity and going out and making contracts, advertising the contracts as not as something you want, but something you have to do. And if you don't do it, or else, if you don't do it, you're breaking the law. But you're not breaking the law unless you sign the contract and then don't do it, because then you agreed to follow the law and then you didn't, and that's the breaking of the contract. That's just like the requirement to file taxes every year. You agreed to file them, so now you have to file them. You took the fiat currency, the legal tender, the contract money, and you implied that now you're going to follow all the laws that are required to be followed by having that contract in place, even if it's an implied contract, meaning you didn't sign anything, but you did a thing, like you used the money. So agencies of the military peace establishment write policy and pass them off as law, advertise them with permission of the Congress, and send their agencies and officers out into the public as salesmen, advertising policies as law, and at times under threat of arrest. Legal meaning contract, and tender meaning voluntary. It can hardly be reasonably said that threatening civil people into contracting with them can be called tender, and perhaps not even legal. Definitely not tender. When they threaten to arrest you if you don't sign their contracts. That's not moral. It's not right. It's not necessarily voluntary. So Department of Motor Vehicles, Department of Transportation, etc., whatever it is in your state, are agencies in the state of whatever state, like Texas, that was created by the federal government, which means they are federal agencies of the military peace establishment. Their agents, officers, etc. are federal military peace officers of the United States military peace establishment. who act as salesmen, advertising a policy and using fear tactics to scare people into obedience. So each state has their own standing army that doesn't look like a standing army, but looks like civil officers who also take an oath to the Constitution. So they take an oath to the federal Constitution, but they also take an oath to the state of Texas Constitution. So some people have claimed that this is a dual loyalty, which is no loyalty at all, but it's not a dual loyalty because the state of Texas is the federal government inside Texas. It's not the civil government, it's the federal government. The civil government is the Republic of Texas, which is still there, which I told you it's still there, and it's written that it's there on the books that are current in Texas jurisprudence under statehood, that it was only abrogated insofar as it conflicted with the federal laws or military works. What they're doing now are not military works, they're commercial contracts, but they're using the federal Constitution or the idea of the federal Constitution to do it to you, to claim the power to do it, but there's no power to do it. There's no jurisdiction of a military establishment outside of the military post unless they were called by the governor of the Republic of Texas as the civil officer, not one established, people say de jure, de facto, or whatever, de facto, as a civil officer who is obedient to the military. It makes no sense for a military of the United States to call itself to establish peace in an already established military state, the state of Texas, and establish peace upon people in the military and those who are civil or not in the military, who are not actively involved in any uprising or riot. So the state of Texas is the military state inside Texas, or the federal government inside Texas. Why do they need to be here among the civil people if they're a military and there's not a problem? Nothing's going on here. There's no uprising. So who's calling them to be here in this state? Because they're just causing problems. So why would you call the military to control the military? It should be controlling itself. During and after the Civil War, and with the help of people like Rockefeller, the federal state constitution, which began with the words, the state of, or quote, capital, all capital, the state of, were propagandized and began to be advertised as constitutions that regulate contracts and commercial activities. They never were intended to regulate commercial activities. They were intended to regulate the military inside of the civil state. The civil class of persons are never subject to the military unless in times of war or uprising, and the federal military peace establishment has been called to restore peace. Yet we find cops, deputies, police, constables, all working for the state of Texas or the state of whatever, policing the civil class of persons who are not on military post. And the Republic of Texas can throw these people out at any time, and that would be called leaving the Union. What is it called? Secession. That would be called secession, I think. Okay, so to secede from the Union. When we kick out the military, that's seceding from the Union, to leave the Union. Okay, so what has become normal, this was my last bullet, but I have a couple other things to read to you about normal or normative things. Okay, so what has become normal may be normative, but if it violates the rights of the people of the Republic of Texas, because they're a military and they can't violate the rights of the civil class of people when we're not at war or there's not an uprising. It's still, when they violate us, it's still unconstitutional. No court opinion of any constitutional interpretation can violate the right of the civil class of persons, even if they were told they could. They can still be held and should be held accountable for their wrongs, including violating their oath. If any officer, agent, politician, military member, or any of them, or all of them, or any one of them violate the rights of civilians, they must and should be held accountable. Ignorance is no excuse. That's what they tell us, right? So now we have norms and normatives. So norms is what's normal. So just because it's normal for us to go and get a driver's license, register our cars, get a birth certificate and all that stuff, it doesn't mean it's right. And it doesn't mean that we have to do it. It may be normal for us to do it, but it's not a law saying we have to do it. So we have something called legal norms, and we have something called natural law norms. Legal normative, or the normativity of law, refers to binding rules, standards, and principles that prescribe, evaluate, and guide human conduct, determining what the law ought to be rather than just describing what it is. So when I read this, I think this is what the state of Texas is telling its military people what they should or should not do. This is what legal normative should have been. But we've been taught to perceive things wrongly, and so it's become something completely different. These norms or policies enforced by authority create legal rights and duties, functioning as practical standards to assess, justify, justify, or criticize actions. So these are supposed to be the policies that the military follows, or the police follow, or anyone that's working in service to us, they would follow policies or legal norms. They turn around and tell us we have to follow those policies. They codify them and then go everywhere we are into our civil state, which is us just doing our personal private things, and tell us now we owe them all this money because we didn't do this or we did that wrong. So the key, and this is right off Google, you can look it up. It's right, both of these are right off Google. So I'm not telling you something I just came up with. I'm telling you what it is. And I've taken a few law classes, and normative was a big thing in one of the classes. And so these are, if you want to learn about normative, just go look up some normative, normative law or whatever. So definition and function. Legal norms establish expectations for behavior in civil, criminal, and other legal areas, operating as a framework for societal order. Not necessarily saying that the military can come out into our civil state and start bossing us around, because the Constitution, the Republic of Texas Constitution, forbids that. But civil people can make laws for themselves. So behavior in civil, criminal, or military, or whatever. They do their thing and follow their norms, and we do our thing and follow our norms. And we don't conflict unless there's some sort of problem. Normative versus positive. Unlike positive law, which is descriptive, normative theory focuses on the evaluation, values, and moral reasons underlying legal action. The moral reasons. So positive law is descriptive, normative is moral. Hierarchy of validity. Legal norms are structured hierarchical, often resembling a pyramid, where lower level laws derive validity from higher level superior laws, starting from a basic norm. So the hierarchy of validity, you have the Declaration of Independence, then you have the United States of America and its Articles of Confederation, and then you have the federal military constitution, the Constitution of the United States. And then you have, and you could put this actually at the top, the republic, state constitutions. And then you have state of Texas military constitutions that operate inside Texas or whatever state you're in. And it's like a pyramid. It's hierarchy. And civil is always over military. Sources of norms. These standards can stem from social practices, behavioral expression, or interpretive theories, making sense of behavior. And then there's obligation. The normativity of law is closely connected to the often debated moral obligation of citizens to obey the law. So citizens can be military citizens, a citizen of the United States, a military person in, like a military person inside Texas, the civil people and how they would act if they were to go on federal lands, or how they act among just ourselves doing our private things. But there's a clear definition between the two. They don't really, military and civil don't really go together as far as the laws that they follow, because military people can be ordered. The civil people cannot really be ordered, but they use the military to order civil people when they get out of hand and start rioting. Natural law norms. So now we're talking not legal, which is contractual. We're talking about natural law. Natural law norms are objective, universal moral principles derived from human nature and reason rather than enacted by government, establishing foundational standards for ethical behavior and justice. These inherent rules, often summarizes as do good and avoid evil, protect essential human rights and guide actions toward flourishing. Core principles and norms of natural law. The primary precept is to pursue good and avoid evil. Basic human goods. Actions should promote fundamental values such as life, health, knowledge, play, aesthetic experience, friendship, practical reasonableness, and religion. Or in other words, stated, life, liberty, and pursuit of happiness. Secondary precepts or moral prohibitions derived from the primary precept. These include prohibitions against murder, theft, fraud, and lying, which is what they do to us when they advertise their contracts. Respect for dignity. Because these rights are inherent, they protect individuals from infringement by others or the state, or any member of any state, whether they're military or civil. And when they don't respect them, the founders called it being humiliated, that the British government was humiliating them by not respecting basic human rights. And the military is, the state constitutions for the military has been offered to be, have been changed to be perceived as contracts that are for commercial activities, governing commercial activities, which is in essence, or in fact, a humiliation of us, because in each of these contracts, they remove some of our basic human rights, like the right to travel or the right not to opt in our babies for the legal state. And about birth certificates, I just want to mention before I forget that there's something called the right of return. And it's ancient and goes back to the time when they were writing on clay tablets. And it says, return to mother. And to return to mother is to go back to your birth state, or your state where you don't have contracts. The state where, and I'm not talking about state as a place, but a state as an internal thing. Going back to the situation that you were in when you were with your mother. So return to mother, you can look that up. The right of return. So the characteristics are discovery through reason. Natural laws are discovered through human rational analysis rather than written laws. Universality, they apply to all people across all times and cultures. Superiority, natural law acts as a higher standard for, and in some traditions, a check on the validity of human-made positive law. Positive law is descriptive, right? Rational response. Morality is seen as a proper response to reasons regarding human flourishing. So why can I not contract you for a driver's license? My rational response is that it's immoral to create a norm that infringes on basic human rights, which is a humiliation to myself and others. So examples in legal ethical context. Human rights, the foundation for inherent rights that governments must respect. Legal philosophy, the basis for challenging unjust laws as articulated by thinkers like Aquinas. International law used for defining crimes that justify universal jurisdiction. These norms are viewed as necessary for human thriving, and adherence to them is considered easier than fighting against them. So that's for them to adhere to our right to natural laws and not be humiliated is easier than them working against us. Okay, so that's all I have for you in this video. I hope this made a little bit more sense as far as the past few videos that I've done. Please consider liking, sharing, subscribing, and talking about these things to other people. I was reading earlier from an affidavit that I wrote. I'm happy to post some of this for you on my YouTube channel. And natural law norms and legal norms are just right on Google. And then the last paper was from the Texas Jurisprudence 3rd edition manual under statehood. And if you know how to read it, what it's telling you is the state of Texas is the federal military state inside Texas, and the Republic of Texas still exists, but was only withdrawn from the areas where the military is doing military federal works. Okay, so again, like, share, subscribe, and you guys have a great week.